In the Idaho 4 case, Brian Kohberger's alibi has been a big issue. Some people say that's rubbish because it doesn't really say anything. Other people say leave him alone. He's got plenty of time. In this episode of About the Law, we're going to take a look at the legal view of the alibi.
Legally, when you look at it, there's some interesting things about the Idaho statute that we're going to go over.
So what is the alibi of Brian Kohberger all about? Should it be thrown out, or does he have plenty of more time to, prove it legally? Joining me today in this episode of About the Law is Southern California attorney Yolanda Medina. Thanks for joining me, Yoli.
Thanks for having me.
How are you today?
I'm doing well. Thank you.
Great. Now, this alibi that Brian Kohberger has now, offered twice, once originally, and then again kind of filling it in and saying he was, he had a habit of running and stargazing at Wawae Park, that raised a lot of eyebrows. And, so I scratched my head. There's just been so much dispute over it. I just thought, I haven't seen anyone really take a deeper dive into the legality of the alibi. Have you seen it?
I haven't. And I also think, the way people view this alibi, the public, they view it as, something that he absolutely has to have in by the deadline. And if he doesn't have it in by the deadline, he's not going to have an alibi, and his alibi is crap. And I hear all of that, but legally, when you look at it, there's some interesting things about the Idaho statute that we're going to go over.
Oh, I agree with you 100%. And we were talking about this before. And so that's why we're going to take a look at that statute right now. And here it is. This is the Notice of Alibi statute in Idaho. It is Idaho Code Section 19-519. And people are very familiar with the first two sections of it, and you only jump in at any time you want.
Okay.
People are very familiar with the first two sections. Under Section 1, Brian Kohberger was asked and then provided his alibi. It says at any time after arraignment, before a magistrate, upon a complaint and upon written demand of the prosecuting attorney, and that's what happened here, the defendant, Mr. Kohberger, shall serve within 10 days or at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defensive alibi. Such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. So that sounds pretty strict, doesn't it?
Right. It sounds like, they have 10 days and they have to produce their alibi. He has to produce his alibi. Otherwise, it seems like he's SOL.
And it seems to me that a lot of the people in the media read that first paragraph and said, "Okay, that's it. Okay, run to the typewriters and get the story." I think a lot of podcasters have too, and said, "Look, he didn't do this. We don't have specific places and specific times, and it's not enough to say that he was out stargazing, and it's not enough to say that he was, at Wawae Park, perhaps." And so people have just taken a look at that one section, and one of my pet peeves is when people say "end of story." Do you ever have a conversation with people or an argument with people and they say "end of story"?
Yeah, it's like, well, end of story. It's not the end.
No. So that's Section 1 of 5 sections.
Right.
So let's take a look at the next several sections. Within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial. So see, that's a big window. Within 10 days after receipt of the defendant's notice of alibi, but in no event less than 10 days before trial, unless the court otherwise directs, the prosecuting attorney shall serve upon the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom the prosecution intends to rely to establish the defendant's presence at the scene of the alleged offense, and any other witnesses to be relied on to rebut the testimony of any of the defendant's alibi witnesses. And this, correct me if I'm wrong, this is the part that the prosecutor, William Thompson, says, I can't do this because they haven't complied with Section 1.
Correct. And basically their response or objection or whatever it was is basically saying, well, he didn't comply with the statute, so we feel we don't have to provide a proper response according to subsection number 2. So basically they're not providing any witnesses that place him at the scene. But again, they have until less than 10 days before trial to do that. Yeah,
I would say shouldn't they present witnesses to put Mr. Kohberger at the scene anyhow? I mean,
yes. I mean, if they have them, I mean, why wait?
I mean, we've talked about this before, and a lot of other people have talked about it too. The PCA, as time goes on, the probable cause affidavit has not been like a fine wine that has aged well. It's been like yesterday's fish, really.
Yeah, moldy cheese.
Oh my goodness!
I mean, it's become just not based on facts so far that can be verified. Like, well, I think the prosecution has to put forth their witnesses, who puts them there, and that's what they're supposed to do. And I would have thought they would have done that long before, and I would have thought that they wouldn't have to be responding to his alibi to put forth those witnesses.
I agree 100%. I mean, is that my whole idea behind doing this special episode on the alibi is that what Mr. Thompson is now hiding behind, and my friend Ashley Jennings, is this what they're hiding behind to now not get more specific behind supporting the PCA? Oh, look, we don't have to do it until 10 days before trial. And I'll answer my question and say yes.
Yes, that's probably what they're doing. Yeah, that's exactly what they're doing.
So let's take a look at number 3. If prior to or during a trial, a party learns of an additional witness whose identity, if known, should have been included in the information furnished under subsection 1 or 2 of this section, the party shall promptly notify the other party or his attorney of the existence and identity of such additional witnesses. So, this just gives them a little bit of wiggle room. This gives them a little bit of wiggle room. I mean, you can't do stuff normally at the last second, but I mean, if you do, quoting section 3, learn of an additional witness, there you go.
Yeah. For example, if the defense has someone come forward during trial and wants to place him somewhere other than the crime scene, well, it seems like all the defendant has to do is provide that information promptly to the prosecution and the court, and that should suffice according to this section 3.
I agree 100%. So let's go back, take a look at section 4. Upon the failure of either party to comply with the requirements of this section, the court may exclude the testimony of any undisclosed witness offered by such party as to the defendant's absence from or presence at the scene of the alleged offense. So I think that's the part that the prosecutors are relying on. But then the final sentence, drum roll, please. This section shall not limit the right of the defendant to testify in his own behalf. Now, I highly doubt that will happen in this case. I mean, don't you?
Well, yeah, I don't think that he is going to testify. He hasn't said one word yet.
No.
And I don't see that he's going to be testifying in his own defense. I don't see that. I mean, you never know, but he hasn't said a word. Out of all the defendants and people in the media who are, accused of a crime, I mean, he has said no. I think he's been the most tight-lipped defendant ever.
Yeah, I agree. He said nothing. He said nothing at all, except for the comment he made right away in Pennsylvania, where he told his attorney in Pennsylvania that he looks forward to being exonerated. And then it said that, and we don't have evidence or tape or anything else, but it is said that he said to reporter Brian Enton, did they arrest anyone else? Or am I the only one? Words to that effect. But yeah, you're right. Since then, he said nothing. But this, to me, is the really interesting thing about the alibi statute. And all these people that are talking about, well, he's got to get the alibi in, or, oh, the alibi's no good, or, oh, whatever. This is the interesting thing to me. Section 5 of the Idaho Alibi Statute says clearly, for good cause shown, the court may grant an exception to any of the requirements of sections 1 through 4 of this section. So that's really interesting to me.
Yeah, and good cause. I'm sure there's case law in Idaho that talks about the definition of good cause, but generally it's kind of a liberal standard. I mean, it's liberal in a sense that it could be a lot of things. Good cause could mean a lot of things. So the court can grant an exception for a lot of things.
Go ahead. I'm sorry.
No, what were you going to say? It's a real what?
It's a real subjective standard. It's not
Yes.
like a lot of things in the law. There are 3 factors or 5 factors, and you've got to weigh the factors against whatever. No, a good cause could mean anything. I mean, to get a continuance, for example, in our courts that I practice in, you've got to have good cause. So what does that mean? What is good cause? I mean, obviously, a death in the family or a serious illness, that's good cause. And obviously, the dog ate my homework is not good cause.
Right.
But where's the line in between? It just, so I agree with you. It's a very, but
Yeah.
moreover, not only does Section 5 of the Idaho Alibi Statute kind of obviate the rest of it, it's kind of like the legislature was sitting down, and I don't know if you have, but I used to actually cover the legislature and go to these interminable hearings that they have on these bills. And it's almost as though somebody said, they had 4 sections, and somebody said, wait a minute, what about the Constitution? Isn't the Constitution more important here? So why don't we throw in another section? It seems to me that it's almost like Section 5 was thrown in at the last minute so that the Supreme Court wouldn't strike down the first 4 sections of it. I don't know, but it looks like that.
It looks like that. And it's like, why even have a statute if you're going to have that catch-all? But I guess it's supposed to be a procedure, I guess, that in criminal law in Idaho that you have to give your notice of alibi and there's timelines to respond. But even still, there's a lot of wiggle room to that. The judge can modify that. And so for those people who think, oh, he didn't get his alibi in and it's not an alibi and he's not going to be able to produce an alibi, I don't know about that. I just think that the defense is having a hard time getting discovery from the prosecution in order to establish an alibi. The information that they need, and I believe that is the subject of the motion to compel, which is the cast report that talks about the finalized cast report. And there's probably other stuff that she needs to assist with the alibi. I think it's hard to do that. And, who's to say if one of the, Bethany or Dylan,
right?
Who's to say that they turn out to be alibi witnesses?
Yeah, I mean, I don't think anybody really believes, with all due respect, I don't think anybody really believes what DM had been quoted as saying in the probable cause affidavit, that it was a person clad in black. That's just not how a 20-something talks.
No.
But, and Bethany has exculpatory information that's been said before in an affidavit that was filed by a very good investigator who's worked on a lot of different cases. But moreover, I mean, I agree with you totally. And I don't think people understand, we're lawyers. And so we just, assume this stuff. I don't think people understand the difference between a statute and a rule. And I agree with you that this statute looks more like a rule of procedure. I mean, we have, I'm sure in California you have the same thing. In Massachusetts, we have a rule book that, now it's online, but it's about that thick. The New Hampshire one's about that thick. But anyhow, we have rule books, and they're called rules of procedure. There's criminal rules of procedure. There's civil rules of procedure. In Massachusetts, all of the courts have their own rules. We have the district court rules, the superior court rules. We have evidentiary rules. And so these are rules of procedure. And they're intended to be followed. And the statute, the first 4 sections of it anyhow, sound like procedural guidelines. I don't know anything about California's rules, but in Massachusetts, in the very beginning, it says any of these rules can be waived for good cause.
I know that in complex litigation in California, and I had cases in complex litigation, we don't even go by the rules. The judge issues the orders for when things are due, you know what I mean?
I don't. I've never heard of that.
Yeah. So in complex litigation, because there's so many parties, so many things, there's actually a section of the court called complex litigation court.
Okay.
And when there's, these cases like with multiple parties and multiple people who are being sued and it cross complaints, and it's just so complicated that the court actually sets a schedule and sets dates and times for things to occur.
Wow.
And they don't necessarily go by the rules of civil procedure. The court is having to manage this big, huge case, and the rules of procedure simply will not allow the parties to litigate, the way it needs to be litigated. So the court can take over and do a scheduling order and assign things, so that's what, when I see Brian Kohberger's case and I see the judge talking about hearings and, are we having hearing or, things like that, I'm like, what? I mean, I would think that the statutes would provide, the time when a hearing should be had, but I guess it's different in Idaho. I don't know, but
I've actually, I'm sorry to interrupt you. I've actually done a dive into the Idaho criminal rules of procedure in the past in previous episodes. Maybe we can do that sometime, because obviously we practice in opposite coasts. We live 3,000 miles apart, and we litigate things very differently. So maybe sometime in the future, as push comes to shove in this case, maybe we should do a deeper dive into the Idaho rules. I've delved into Rule 16, which is the discovery rule, and says what the defense can demand that the prosecution give them over and above the Brady disclosures that they must give them. And it goes into things like photographs and documents and blueprints and witness statements and all that kind of stuff. I think it's Idaho Criminal Rule 16.
I'm sure there's case law that interprets this alibi statute, but just by the words of the statute, it seems that there's a lot of wiggle room.
Yeah, so the final point I wanted to make before we move on is that the statute itself says, for good cause shown, the court may grant an exception to any of the requirements of sections 1 through 4 of this section. So anyone that is telling you that, oh, he missed the boat on the alibi, and so forget it, he doesn't have an alibi, that's not in compliance with the statute. And moreover, you and I both know that the statutes are fine, but it's the Constitution that overrides all of them. I mean, all statutes must be in compliance with the Constitution. The Constitution is the overriding law that all other laws have to be in compliance with. And I don't know if Idaho has a analog to Marbury versus Madison, but Marbury versus Madison, way back at the beginning, the formative years of the United States, came out and said, the Supreme Court is the final arbiter of these statutes, guys. You guys can do whatever you want in Congress, but what we say here in the Supreme Court goes, and we can overrule your statutes. And I would assume that Idaho follows that. I mean,
I think so. I probably can assume that as well.
Yeah. So let's move on to, now that we've talked about the law, let's apply the law to the facts. Isn't that what we always do?
Yeah.
So what did Mr. Thompson say? This is the objection that the state, see him up here at the top, William W. Thompson Jr. And Ashley Jennings. This is the response that they filed to Brian Kohberger's notice of defendant's supplemental response to the state's alibi demand. And they came out really strongly. The state respectfully submits that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19519, which we just looked at, which provides that the defense shall state the specific underlined place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such an alibi. So he goes on and on and on, and he just kind of repeats the alibi. As to the defendant's reference to potential testimony about the location of defendant's cell phone on the morning of November 13th, this information does not rise to the level of an alibi at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. The location of defendant's cell phone at times other than the time of the homicides is not proof of or relevant to the defendant's specific location at the time of the homicides, approximately 4 o'clock to 4:30. Well, I spot a couple of issues here. What are yours?
Well, one of the things is that we're relying on the defendant, on the prosecution's witnesses that state that defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. I think that is the prosecution assumes he turned it off because he was going to go commit the crimes. Now that's an assumption that that would have to be proven that he turned it off.
Yes.
And to that end, I don't know much about the technology, but that's an assumption that they assume, because most criminals turn off their phones, when they're going to.
I couldn't believe it when I was reading the probable cause affidavit, which is supposed to be facts. An affidavit is supposed to be facts. Towards the end of the affidavit, the affidavit comes out and says, well, it's usual in my experience that criminals turn their phones off. That's an opinion, and that should be stricken from the affidavit, in my view.
Absolutely. Absolutely, it should. In my opinion, again, I don't practice criminal law in Idaho, but it's an assumption that is made, and that assumption has to be proven. So I don't know how they're going to prove that, other than, they're trying to prove it by the declarant's testimony that in his experience, criminals turn off their phone. Well, yeah, in my experience, criminals don't take their phone.
No. I guess you could bring in a prosecutor, a seasoned prosecutor, and the prosecutor could say, yes, we find that criminals always turn their cell phones off, in my opinion, but then you have to qualify the guy as an expert based on his knowledge, education, and experience. So
and are those criminals who have a criminal past? Because Kohberger doesn't have a criminal past except for that one when he took his sister's phone. But
he took his sister's phone, right. But the other thing that bothers me, and you kind of alluded to it, is that they say it stopped reporting the location at the cell phone at all times other than the time of the homicides is not proof of or relevant to the defendant's specific location. Well, what if he was in this park where there is no cell service? Even in 2024, I think I said this in a previous episode, but it fits here too. Even in 2024, there are places where my cell phone drops out and there's no service. Mm-hmm. So, all right. So,
yeah. And one other thing is, and I don't have the PCA in front of me, but I know that they have him going in his alleged vehicle going in a certain direction on the road when the crimes were committed. Right. And it's like, how can he be two places at once?
Well, I think that's why they mentioned the weed shop in the alibi. Okay, so we go on with Thompson's the prosecutor's statement. It is the state's position that the defendant continued failure to adequately comply with Idaho Code 19-5191 does not trigger a response under Idaho Code 19-5192. And this is what you had mentioned before. If the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code 19-519, the state requests additional time pursuant to Idaho Code 19-5195 to prepare a list of witnesses to establish the defendant's presence at the scene of the homicides. And there he goes again, hiding behind the alibi statute when guys,
they should have.
Shouldn't you have witnesses now? I mean, if Dylan Mortensen is a good witness, if she's your witness, okay, what other witnesses do you have? I mean, what about Bethany? What about, there are all these foggy kind of images, and people keep putting down in the comments, didn't you see so-and-so's episode where he sees the car turning around 3 times and he sees it over here? I saw a fuzzy car.
There's no license plate.
Yeah.
As far as I know, they don't have a license plate for that car.
So, now it's been approximately 11 months since the state filed its request for disclosure alibi demand on May 23rd, 2023, and almost a year and a half since the homicides occurred. The defendant has been given more time than he is legally entitled in order to provide his... No, that's not true at all. That statement is just not true because from reading the statute, the latter sections of that statute, all of that can be waived.
Right. Right. And it's the state's burden to prove Mr. Kohberger is guilty. And by reading this, where, it's been approximately 11 months, since the state filed its request for disclosure alibi, and almost a year and a half, the defendant has been given more time than is legally required. Okay, that's fine. But he does not have the burden. Okay.
Absolutely not. No,
he does not have the burden of proving any defense. The prosecution first has to prove or provide, evidence that he's guilty, and then he provides his defense in court. You know what I mean?
Absolutely. Yeah. The defendant, the prosecution bears the burden of proof on each and every element of the crime and all 5 of the crimes in which she was indicted. And they have the burden of proof all the way through for everything. And so to kind of hide behind the alibi issue is a rabbit hole that they're trying to dive down and then poke their heads out and say, oh, yeah, we don't have to provide our witnesses now. Yeah, you do. And
we need more time. But if we do have to provide our witnesses, we need more time.
Right. Now, my understanding, and I haven't looked at it lately, but the prosecution's discovery deadline is in September, I believe.
Yes.
And then the defense's discovery deadline is in January. So, the alibi statute has absolutely nothing to do with their requirement to prove each and every element of the crime, but moreover, to provide their witnesses. So anyhow,
exactly, witnesses that they should have already had. I mean, they have at least one that is stated in the PCA DM.
Well, like I said before, the probable cause affidavit has not really aged well, has it?
No.
I said it wasn't like a fine wine. You said it was like a rotten cheese.
Moldy cheese, yeah.
Moldy cheese. Some people like that, by the way. Not me. I'm not one of those people. Okay, so there's an article that I did find when I was looking for information on this issue. Here we go. Here's an article that was published in Seattle in the local Fox News channel just on May 2nd of 2024. And what they said was Brian Kohberger's alibi was ripped apart in the Idaho prosecutor's temper tantrum. I kind of like the way they put that. I mean, sometimes people say, just when I'm trying to be objective, they say that I'm, siding with one party or another. So if I find someone else that agrees with me, I'm going to put it on. So I'm not going to read the whole article, but Idaho student murderer's suspect Brian Kohberger's alibi that he was driving around looking at the moon and the stars is too vague, according to prosecutors. And we've heard this. We've been talking about this. But the part I found interesting is down here. The prosecutor's concerns may not be enough to convince the judge. However, according to Edwina L. Cox, a Boise-based defense attorney who previously represented the cult mom killer Lori Vallow, quote, "It is not up to the state to determine what is or is not relevant to the defense," she told Fox News Digital. "Try as they may to control the narrative." And this is kind of like what you were saying before. This experienced defense attorney, L. Cox, noted that Kohberger has a constitutional right to mount a defense and called the latest filing the prosecution's equivalent of a temper tantrum. I found that wording kind of interesting.
It is. It's descriptive. I mean, yeah, he has this whole idea that, oh, he's screwed, he can't provide an alibi, all this stuff. It's kind of it's how should I say? It's not accurate. That's
it's a red herring.
Yeah, it's a red herring, because there's, like I said before, I mean, if at the last minute somebody comes forward, they're not going to say, oh, you didn't follow the rule, and so because you didn't follow this rule, you're going to get sentenced to death. I mean, death is the most severe penalty. It's not going to happen.
Well, first of all, I agree with you. It's not going to happen. Second of all, if it does, that'll be grounds for appeal. I mean, I've already flagged, I don't know, a half dozen or a dozen issues for appeal, and I'm sure you have too.
Oh.
But that would obviously be one. And didn't Jay Logston say in one of the hearings earlier that this case could be going on for 28 years?
He did.
So yeah, if they sentence Mr. Kohberger to the firing squad, that I think that'd be a really obvious appeal, as I said before, under Marbury versus Madison, and I'm fairly certain that Idaho would have an analog to that. The Constitution overrides a statute, even though this statute has a lot of wiggle room, as we pointed out. So I don't know. It's just. I just mentioned Logston talking about how it could be 28 years. In one of my previous episodes, I did an analysis briefly of a Massachusetts case in which a defendant by the name of James Cater was tried 4 times, and there were 22 appeals.
Yes. And over here in California, there was a serial killer, Rodney Alcala.
I've heard the name, but I don't know anything about it.
Yeah, he was his own lawyer. He was brilliant. And that case went on decades.
Really?
And he kept getting new trials and new trials.
I want to look into that one. I want to look at
Rodney Alcala. I actually watched part of the hearing because it was the latest appeal was for a murder that he committed in Orange County, where I live. And I took one of my godsons to go see, because at that time Dexter was really, the show Dexter,
Mm-hmm. Yeah.
And so he was really fascinated with that. I said, you really want to see a serial killer? I took him to the trial.
Oh my God. How old was he?
Oh, he was like 16.
Oh, okay. All right.
Yeah, he was 16, 17.
Mm-hmm.
And boy, it was scary. But that case, decades and decades. I mean, and he was his own attorney, and he kept getting motions. He kept getting his motions for a new trial granted.
And what was the final outcome?
He was found guilty.
Okay. Same with the case I was talking about, the James Cater case in Massachusetts. 22 appeals, and he had all kinds of lawyers. He had some of the best lawyers that there are in Massachusetts, but 22 appeals, and I forget, it was about 24 years from start to finish in that case. It sounds like your case, which I'm going to look into, sounds interesting.
Yes.
Sounds like your case went on even longer.
Yes, and he's the dating game killer. I don't know if you've heard of that.
Oh, yes.
Mm-hmm. Where he was on a dating game, and he had one of the earrings that one of the victims had. Yeah, that's the guy.
I think Dr. Gary Brucato mentioned him in his book. I read that book, but I just read so much I forget where I read stuff. Brucato wrote an excellent book. I've been trying to get him on the podcast, still working on it. But I think he talked about Alkali and likened him in a sense to Ted Bundy, because Bundy was a smart guy. He was a smart guy, and he was his own attorney. He did have attorneys come in here and there, but he was his own attorney, which kind of proves the old adage, he who represents himself.
Yeah. Right. And so Alcala, when he spoke, he had a very strong presence.
Why do these people waste their lives if he's so smart and he has such a great presence? Why did he have to? Ted Bundy was a charming guy. He was rising in the political parties in Seattle, Washington. He worked with Ann Rule at the suicide hotline. He was working to a legal degree, and he, was a charming guy who was persuasive. But what is it? This is what I would ask Brocato about. What is it about people like Alkali and Bundy that just, instead of using this brilliance that they have, that they go down a different track?
I don't know. It sometimes I wonder if it has anything to do with when they were born. Like something happened during the delivery, and that combined with family dynamics made them the way they are. But that's just speculation on my part.
I think the forensic psychologists, and who was the woman that wrote the book about BTK, DeKalb Institute?
Ramsland?
Yeah, Catherine Ramsland. I read her book about BTK, which is really a fascinating book. And she has a degree, and she's dedicated her life to this information. She asks the same questions that you and I are asking right now. And she doesn't come to a conclusion. She just kind of asks the question, is it organic? Is it situational? Is it a combination of those two? Is there something wrong with their brain? So it's a conundrum. And so I return back to what I said before. If people are that talented, why aren't they, using those talents for, a good thing?
And convert negative energy into positive energy. And that's something, I don't know.
On a sidetrack, I've just been watching some really brilliant kids that just are so talented. Now, I've been trying to play the guitar for years. As you can see, my little bass guitar over there, over there in the corner, and I still have to take lessons. I still can't play. It's still hard for me. And I've recently been watching some kids on YouTube that are just so brilliantly talented, and I just hope that they stick with it and become, the next Beatles or the next Rolling Stones or the next whoever. Anyhow,
yeah.
Do you have any final thoughts for us?
No, just that the alibi is not as concrete as people think it is. It doesn't have to be in. I mean, per the rules, it has to be in by a certain time, but that's not really. It's just the Constitution overrides it. So he's not dead in the water because of the alibi that he did produce at this point.
Oh, absolutely. And this, the fact that the what has happened with the alibi has really divided people and made people feel really strongly one way or the other. Folks, it's a sideshow. It's a sideshow. It really, in the long run, it really is not anything that really is going to control this case. Yoli, thank you very much for joining me. I appreciate the time that you gave me today.
And thank you for having me. It was nice.
Have a good one. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And that's that.
Yeah. Yeah.
I thought this episode would be a lot shorter. I don't know. We went a whole 40 minutes. I thought it'd be a lot shorter. Okay. Have a good one.
Okay. Bye-bye.
Bye.